Oh, thank you for turning off your cell phones. Okay, we've now begun our program. Welcome. Welcome to the National Archives Know Your Records program. Today we are doing a presentation on U.S. constitutional amendments. We are broadcasting live from the National Archives building in Washington, D.C. We have an audience here with us on site in the McGowan Theater, and many of you are also joining us online via YouTube. Before we begin, I have a few tips to share with you on how to participate in today's program. For those of you who have joined us on site, we will take your questions, but we ask that you hold on to the very end. And when you have your question, if you can make your way to these microphones in the aisles so that our online audience can also hear you. For those of you who are watching online, you can also ask questions. You'll do that by first logging in to YouTube and using the chat feature. Type your questions in, and I will ask the presenter your questions for you, again, at the end of the program. You'll also find two hyperlinks on this web page. One will take you to the presentation slides. The other will take you to live captioning. So for today's program, Christine Blackerby will discuss the records used in our new exhibit, Amending America, celebrating the 225th anniversary of the ratification of the Bill of Rights. Ms. Blackerby is an education and public outreach specialist at the Center for Legislative Archives, National Archives and Records Administration in Washington, D.C. She does public and educational outreach programs to highlight the history of Congress. Ms. Blackerby received her BA in History and Political Science from the University of Illinois at Urbana-Champaign and her MA in Education at the University of Kentucky. And now for our presentation, U.S. Constitutional Amendments. Ladies and gentlemen, please join me in welcoming our presenter, Christine Blackerby.
Good afternoon. What if we elected the President of the United States by lot, by pulling a ball? A constitutional amendment introduced in Congress in 1846 proposed precisely that. In 1838, one member of Congress shot and killed another, prompting the introduction of an amendment to the Constitution to deny public office to duelers. A citizen wrote to Congress in 1963 to advocate for a constitutional amendment to require that Americans tell the truth, the whole truth, and nothing but the truth. Anyone who failed in that duty would be sentenced to 20 years of hard labor. These are just a few of the more than 11,000 constitutional amendments that have been introduced in Congress since the Constitution was written. Some of them were proposed to call attention to an issue, some as satire, some to allow a member of Congress to take a political stand, and some were very serious appeals to resolve pressing issues. What most of these proposed amendments have in common, though, is that they failed to be enacted. Only 27 of the more than 11,000 proposed amendments have been ratified to become part of the Constitution. It's difficult, but not impossible, to turn an idea into an amendment. The reason so few amendments have been successful is that our Constitution, in Article 5, sets a very high bar to pass amendments. Each of the 27 ratified amendments have gone through a two-part process. They passed both houses of Congress by a 2/3 vote, and then they were ratified by 3/4 of the states. So what kinds of proposals have achieved enough support to become ratified amendments? And what failed? These questions are explored in Amending America, a new National Archives exhibit. Amending America features National Archives documents that highlight the successes and the failures of Americans' attempts to change our nation's fundamental governing charter. Today, I have taken a selection of the documents and stories from this exhibit to share with you. But before going into the exhibit stories, I'd like to take a minute to give you a little bit of background. 2016 is the 225th anniversary of the ratification of the Bill of Rights. And years ago, when the idea for this exhibit was still percolating, this anniversary struck co-curator Jennifer Johnson and I as an excellent opportunity to highlight one of the founding documents in the National Archives. But we also wanted to look at all 27 of the ratified amendment, as well as some of those that failed. The records at the National Archives tell the stories of the amendments through those amendment proposals in Congress and through film, photos, and other documents. Because I work in the Center for Legislative Archives here in the National Archives, I knew that congressional records contained a wealth of material on this topic. Those 11,000 amendments were introduced in Congress, and most left some paper trail, which I was thrilled to be able to investigate. So many of the documents you see here today, and in the O'Brien Gallery here in the National Archives building, if you're able to visit, come from the historical records of the US Senate and the US House of Representatives. We started this project by researching those 11,000 amendment proposals in Congress. And as we sifted through those proposed amendments, we noticed that they tended to fall into three broad categories: those that relate to individual rights, the powers of government, and to the structure of government. There are some outliers, of course, like this one that would have changed the name of our country to the United States of the world. But those three broad categories that I just described form three of the major themes that organize the exhibit. And the fourth theme is called How We Amend, and that part discusses how an idea actually becomes an amendment. Today I'm going to start with some of the stories about documents that are in the theme called Our Rights. 17 of the 27 ratified amendments secure or expand individual rights, which means that much of the history of constitutional amendments is a history of expanding rights and expanding democracy. The amendments in this category include, of course, the Bill of Rights, voting rights, and those that relate to equality. And as part of the celebration of the 225th anniversary of the Bill of Rights, we looked at why we even have one in the first place. The omission of a Bill of Rights from the Constitution was a deliberate decision, not an oversight. But that decision proved to be a mistake so large that it was almost fatal to the Constitution. Near the end of the Constitutional Convention, Delegate George Mason of Virginia suggested that a Bill of Rights be included, but it wasn't a very popular idea at the convention. Some delegates thought that a Bill of Rights was at best unnecessary and at worst dangerous. James Madison thought that no list of rights could ever be complete, and that listing them meant that any right left off could be seen as having been given up. It was best, therefore, to make no list at all. Many delegates also believed that they had created a government of limited powers that would not have the ability to interfere with individual rights. And so the state delegations at the convention voted on whether or not to include a Bill of Rights, and as you can see here, they voted it down 0 to 10. Then the Constitution was sent to the states to be ratified, and the first 5 state ratifications happened fairly quickly. But anti-federalists who opposed the Constitution and wanted to defeat it focused on the lack of a Bill of Rights. Massachusetts was the first state where it looked like the Constitution could possibly be defeated, partly due to a lack of a Bill of Rights. And faced with the prospect of a conditional ratification, or worse, a second constitutional convention, the Federalists had an idea to prevent that from happening. The Massachusetts Convention was encouraged to ratify the Constitution unconditionally, but to recommend amendments under Article 5 of the Constitution that could be made by their representatives to the first Congress. This was agreed to, and Massachusetts ratified the Constitution. 6 of the 7 remaining states followed this pattern: unconditional ratification with recommended amendments. The Constitution would likely never have gone into effect if these states had not been willing to accept the Constitution as is, with the promise of a Bill of Rights in the future. Here you can see New York's recommended amendments. New York's ratification of the Constitution covers 6 large sheets of parchment. It contains the full text of the Constitution and then 3 pages of recommended amendments. They listed amendments related to rights first, which is what you see on these pages here. Then several which would have altered the structure or the powers of the federal government, especially the taxing powers. Those later suggestions were wholly ignored by the first Congress. These recommended amendments did ultimately have an impact. Here you can see similar language, very similar to what ended up in the final ratified version of the Bill of Rights. This line from New York's ratification is about prohibiting search and seizure, which ended up in the 4th Amendment in the Bill of Rights. And this line here is about the free press, which was included in the First Amendment. But when James Madison drafted the Bill of Rights in the first Congress, he made an important change from the suggestions made by the state ratifying conventions like New York's and the state's bills of rights that served as a model. That change would become significant in the first half of the 1900s. Most of those earlier models had used language that suggested that the rights were guidelines. They used words like should or ought. But when Madison wrote the amendments that became the Bill of Rights, he used different language. He used shall and will. And as such, he turned a set of beliefs into legally enforceable limitations of power. And this became incredibly important in the 20th century as violations of rights increasingly ended up in the Supreme Court. This document is one of my favorites in the exhibit. It's a draft version of the Bill of Rights. We usually refer to this one as the Senate markup. The printed text contains the amendments as they were passed by the House of Representatives, and then the handwritten notations were made during Senate debate. This is one of the most interesting documents to see up close, which you can in the O'Brien Gallery here at the National Archives building, because you can actually see the creation of the Bill of Rights in progress. The Senate took the 17 amendments that had been passed by the House and edited and condensed them down to 12 amendments. And after a conference committee, those 12 amendments were sent to the states for ratification. The Bill of Rights officially became the first 10 amendments to the Constitution when Virginia ratified them on December 15, 1791. Of the 14 states then in the Union, Virginia was the 11th to ratify, thus providing the constitutionally required bar of 3/4 of the states needed for ratification. And since 1941, December 15th has been celebrated as Bill of Rights Day. Well, at least it's celebrated by history nerds like myself. I'm not really sure about anyone else, though. After the Bill of Rights was ratified, it was mostly forgotten. Until the 20th century, it served mostly as a statement of principles, a set of beliefs agreed to by most Americans. It didn't really have much of a direct impact on most people. As originally written by Congress, the Bill of Rights constrained only the federal government. State governments could still encroach on these fundamental rights, such as free speech or the press. Ratified in 1868, the 14th Amendment changed that. Eventually. It was not until the 20th century, though, that the Supreme Court began to interpret the Due Process Clause of the 14th Amendment to require that states also protect individual rights, not just the federal government. And case by case over decades, the Supreme Court ruled that most of the Bill of Rights applied to the states, a process referred to as incorporation. This incorporation of the Bill of Rights considerably expanded its reach, and more Americans began to fight for the rights that had previously been unacknowledged. There are many documents in the Amending America exhibit, of course, that are proposed amendments, but most of them are draft versions. The only amendment that is displayed in the gallery in its final enrolled form is the 14th, which you see here. The footprint that this amendment has left on the roll of rights in our nation has been quite impressive. So after illustrating the story of how we came to have a Bill of Rights, Amending America goes on to tell some really cool stories about those first 10 amendments. The First Amendment is probably the most well-known. It protects the freedom of religion, speech, and press, and the right to assemble, and petition. And the National Archives holds many documents that portray those rights in action. Like this one, for example. In the early 1960s, the Supreme Court invalidated the common practice of teacher-led prayer in public schools as a violation of the First Amendment's Establishment Clause. In response, members of Congress introduced literally hundreds of constitutional amendments, both to protect school prayer and also to confirm that school prayer could not be required. Others urged Congress not to change the First Amendment at all. This letter from a Baptist church stated that these proposed amendments addressed a problem that did not exist. God and the Bible never left schools, the letter writer pointed out. Students could still pray. The court had only stated that compulsory prayer was unconstitutional. The letter ended with a plea. Leave the First Amendment as it is. It gives me the freedom to worship as I desire and the freedom to petition the government for redress of grievances. This I am doing. One of the most fun parts of curating this exhibit was finding documents held by the National Archives that most people would not expect to find in the records of the federal government. Like, for example, comic books. This comic book was one of over 600 collected by the Senate Judiciary Subcommittee on Juvenile Delinquency during a 1954 investigation to determine if such comics contributed to youth crime. But the investigation exposed an important question. Does the First Amendment's protection of the free press include crime and horror comic books aimed at children? Although the Senate did consider censoring this kind of publication, ultimately it proposed no corresponding bill. The Fifth Amendment plays an important role in the history of Hollywood and the motion picture industry. The Fifth Amendment includes many protections for people who are accused of crimes, including the right to not incriminate oneself. In the 1950s, that right became the backbone of the defense for many Hollywood actors, writers, and directors who were accused of being communists or communist sympathizers by the House Committee on Un-American Activities, also known as HUAC. In this committee's attempt to stop the influence of communism on American culture, they subpoenaed many in the motion picture industry to testify about their political thoughts and beliefs. Many of those who were called to testify, like playwright Lillian Hellman, who wrote this letter, refused to answer questions about their beliefs or about the beliefs of people they knew. This was a right they had under the Fifth Amendment, and in exercising that right, they pled the Fifth. And the HUAC records are filled with examples of people who chose to do so, like Hellman here. Five of our 27 ratified amendments expand voting rights. Because the Constitution gives each state the right or the power to determine voter qualifications, a constitutional amendment is required to guarantee any particular group of Americans the right to vote. Some states have historically excluded groups from voting, such as African Americans, women, illiterate persons, felons, or young people. The first amendment to address voting rights was the 15th Amendment, ratified in 1870, 5 years after the end of the Civil War. It forbid any state from denying the vote to anyone on account of race, color, or previous condition of servitude. However, violence still prevented many African Americans from voting 95 years after the 15th Amendment was ratified. The Congress of Racial Equality, known as CORE, submitted this photograph to Congress during consideration of the Voting Rights Act of 1965. CORE used this photo to illustrate the need for federal legislation to protect voting rights. The caption on the photograph noted that this voting education site for African Americans burned to the ground because the fire department never came. The Voting Rights Act, after it was passed, did vastly increase the number of minority voters. Some amendments that were introduced in Congress attempted but failed to solve a problem that was successfully addressed by a later amendment. Before the 19th Amendment granted women suffrage in 1920, an 1888 resolution proposed voting rights only for widows and spinsters. suggesting that married women were represented by their husbands. Part serious and part mocking, Elizabeth Cady Stanton testified to Congress in support of this proposal, stating, "They are industrious, common-sense women who love their country, having no husbands to love, better than themselves." This proposal failed, but 32 years later, all women got the right to vote with the 19th Amendment. The second theme in the Amending America exhibit is called Refining Powers. And the amendments featured here ask the question, what do we want our government to do for us? The Constitution authorizes many powers for the federal government, but Americans have continued to tinker with this list. Many amendment proposals would have created new powers, like a 1911 proposal to give Congress the power to protect migratory birds. But some amendments proposed would have take powers away from Congress. The decision to declare war is a critical power given to Congress in Article 1, Section 8 of the Constitution. But after World War I and during the Great Depression, some war-weary petitioners sought an amendment that would take that power away from Congress. Instead, it would give the people the opportunity to vote on whether or not we are to be plunged into another foreign war. This fierce sentiment kept America out of World War II until 1941, but it wasn't strong enough to actually get into the Constitution. Attempts to codify proper behavior through amendments have been unsuccessful, but that hasn't stopped anyone from trying. The establishment of Prohibition in 1919 with the ratification of the 18th Amendment was the capstone of decades of efforts by those who supported moral living by refusing to drink alcohol. And the 18th Amendment prohibited the manufacture and sale of alcoholic beverages in the United States and was generally referred to as Prohibition. But Prohibition failed after 14 years, and in 1933, the 21st Amendment repealed the 18th Amendment, and that is the only instance of that ever happening. However, 5 years after the end of Prohibition, some people could still not let this idea go. But instead of prohibiting alcohol sales, an amendment proposed in 1938 would have regulated personal behavior by prohibiting drunkenness. Given the difficulty of enforcing Prohibition was one of the chief reasons why that failed, the absurdity of enforcing this ban was cheekily pointed out in the handwritten note at the bottom of this amendment, which said, "Why not add Section 3, that period of time commonly known as Saturday night is hereby stricken from the calendar of the United States and abolished." And also Section 4, Congress and the several states shall have concurrent power to change human nature from time to time in its or their discretion. We don't know who added that handwritten note to the bottom of this amendment. It could have been another member of Congress or it could have been a clerk, but I don't think we'll ever be able to find out. Child labor was a topic that sparked emotional reactions. This letter from a woman named Suzanne Heber conveys, sorry, I went too far. Conveys her horror at seeing the lives ground out of mere babies by hard labor. The cruelty she witnessed spurred her to support child labor regulation. After the Supreme Court invalidated several child labor laws, Congress proposed the Child Labor Amendment in 1924, but it was never ratified by 3/4 of the states. Subsequent legislation was upheld, and the proposed amendment became moot. But the handwritten note below the signature adds an interesting dimension to the letter. The progressive era of the early 20th century spawned many major societal changes and reforms, and some of them impacted each other. This note added by Heber at the end of her letter ties together two of the great amendment campaigns of the progressive era: child labor regulation and women's suffrage. Under her signature, it says, "One woman who wants the ballot for the purpose of helping these helpless little ones." And I'll go back to the one I skipped. Sorry about that. In 1838, Representative William Graves of Kentucky shot and killed Representative Jonathan Silly of Maine in a duel at the Bladensburg Dueling Grounds in Maryland. which is just a few miles away from where we are now. Although duels had been seen as demonstrations of bravery and honor, they eventually became an unacceptable way to resolve disputes. Members of Congress introduced 2 amendments to forbid duelists from holding public office, but eventually neither one of them succeeded, and dueling itself ended up pretty much fading away. The third section of the Amending America exhibit is called The Shape of Our Government. And the founders who wrote our Constitution were constructing something totally new, and they didn't know for sure if or how it would work. It would not have surprised them then that time would reveal some flaws or inefficiencies, and many proposed amendments would alter how the federal government is structured, who is allowed to participate in it, and how the candidates are elected. Some of these ideas fix difficult problems, but others are head-scratchers. I'm not sure exactly what problem would be addressed by an 1875 amendment to establish a 6-year term of office for the president, after which the president would serve as a senator for life. This sounds less like a term of office to me and more like a sentence of punishment. One of the structures of the government that this amendment proposed to change was apportionment. In other words, how many citizens would be represented by their member of the House of Representatives. The founders had agreed to several compromises in order to create the new Constitution. One of the most controversial compromises was over slavery, including the infamous 3/5 clause. These petitioners from Ohio ironically highlighted the hypocrisy behind the 3/5 clause in the Constitution, that slave states claimed that slaves were property on the one hand, but also counted them as 3/5 of a person for representation in the House of Representatives. These petitioners asked that the Constitution be amended to completely eliminate the 3/5 clause. But then they added, but if that was impracticable, that the animal property of the free states be represented as well as the slave property of the slave states. Not surprisingly, this engendered a strong negative response from the slave states, and the proposal died. Citing extensive moonlighting, junketing, and political campaigning, Senator Margaret Chase Smith proposed an amendment in 1971 to punish absenteeism in Congress. Her amendment would have expelled any member of Congress who missed more than 40% of the roll call votes. This is another one of the 11,000 failed amendments, partly because the language in the amendment was so inflexible that it didn't exempt members of Congress for being absent due to illness. And then opposition also came from other members of Congress who felt that voting was only one way that members served their constituents at home. This does seem to be one of the more popular proposals, though, that some people would like to see reintroduced in Congress. In the progressive era of the early 20th century, the Senate was alleged to be corrupt, unresponsive to citizens, and filled with millionaires who spent too much on their campaigns. This letter is indicative of the typical thoughts about the Senate amongst many people. The State Grange of Illinois, who sent in this letter, that's an agricultural organization, they wrote to Congress in 1898 to advocate for a constitutional amendment for direct election of senators. They were short and to the point. Whereas the Senate is largely composed of millionaires who frequently owe their election to lavish expenditures of money, resolved, in order to make them more directly accountable to the people, they should be elected by popular vote. And this cartoon by Clifford Berryman from the Senate collection points out another problem with the Senate during this time period, which was election deadlocks. The Senate was initially understood to represent the states in our system, and as such, the Constitution directed that state legislatures would elect the senators. But when both houses of a state legislature didn't agree on a candidate, the election deadlocked and the Senate seat remained empty. This cartoon illustrated how common such deadlocks had become when Congress finally addressed the problem by proposing what became the 17th Amendment, which was ratified in 1913, and it provided for direct election of senators by the people. The 12th Amendment to the Constitution did such a great job at solving its targeted problem that most people don't even know why we have it or what it does. The 12th Amendment was a direct response to a flaw in the Electoral College system that was devised by our founders. As originally written by our founders, each elector in the Electoral College cast 2 votes each. Whichever candidate received the most votes would become the president, and the person in second place would become the vice president. But the 1800 presidential election was different from those that came before it. This was the first election where the candidates ran as a ticket for a political party, as a team with a presidential and a vice presidential candidate. So when the electors cast their votes for their party, they cast 1 vote for each of their party's candidates. The result was, not surprisingly, a 73-73 tie between the 2 candidates of the Democratic-Republican Party, Thomas Jefferson and Aaron Burr. The election was resolved in the House of Representatives after 36 ballots, only when Alexander Hamilton encouraged the House to elect his adversary, Thomas Jefferson, over his future mortal enemy, Aaron Burr. It was clear then that such tie votes would continue to occur unless the Electoral College was changed. In 1804, just in time for the next presidential election, the 12th Amendment directed that the electors specify which of their 2 votes was for president and which was for vice president. And that successfully ensured that a tie vote would not occur again. Many documents in the National Archives indicate that Americans are clearly not enamored of that unique design in the Constitution, the Electoral College. Although the 12th Amendment modified it, the Electoral College has been the target of hundreds more proposed amendments. One of many ideas suggested in Congress for replacing the Electoral College system was to elect the President of the United States by lot. House Joint Resolution 8 in 1846 proposed that a ball would be picked from an urn, and then a candidate from the state marked on the ball would become the president. A second ball would be selected to choose the vice president. At a time when there was fierce competition between the slave states and the free states to elect a president from their own respective regions, the randomness of this method may have been a purposeful attempt to sidestep growing sectional rivalries in the time period prior to the Civil War. In this way, neither side could claim to be winning, and we could all stay friends for a little bit longer. To us, however, it seems just a little bit absurd. And importantly, it suggests that many of those 11,000 failed amendments might not be a bad thing. The final section of the Amending America exhibit is called How We Amend. It attempts to explain the amending process and some of the issues surrounding it. The process can be complicated, so one thing that we did differently was to work with the History Channel to make an animated video of the process. It does a fabulous job of illustrating the steps of the process in a really easy to follow way. And this video is available on YouTube on the National Archives channel. I just included a still from it here so you could get a look at it. The National Archives also has a role in the amending process. The Archivist of the United States, the head of the National Archives, is responsible for certifying that constitutional amendments have been properly ratified. The National Archives also holds other federal records relating to the creation and the application of the amendments. This document is the certification of the 27th Amendment, the last one that was added to the Constitution in 1992. And it was signed by by the Archivist of the United States, Don Wilson. There's a few more items related to this exhibit that I wanted to share with you. I've already mentioned that to make this exhibit, we sifted through the list of 11,000 introduced amendments. That list is actually a series of amendments, a series of lists published by Congress at various points in time, somewhat randomly. But as part of the project, we took that paper list and we entered it into a spreadsheet to make it searchable and sortable for the first time. So we've made that list, that spreadsheet, available for free downloading at data.gov. And I'm really excited to see how some intrepid political scientist in the future can take this information and find out even more about constitutional amendments than we were able to do for this exhibit. The other thing we wanted to do was invite our visitors to participate in the exhibit. So this screenshot is from a poll that is live in the Amending America gallery right now. After seeing all the stories of the successes and failures of amending, we are asking our visitors to share their thoughts on what the next amendment to the Constitution should be about. Visitors can text their answer to the question, how would you amend the Constitution next? And the 4 answer choices that you see here come from amendments that have been introduced in the current Congress and therefore are live issues. Our founders knew that they had made an imperfect document. They left it to us, their successors, to address problems, and they gave us the means to do it through Article 5 of our Constitution. The founders also made the bar for introducing constitutional amendments pretty low, but the bar for ratifying them very high. Did the founders strike the right balance? That question has been debated for over 2 centuries and continues to be a question today. So why do we amend the Constitution? We amend when Americans share an understanding of an essential concern that affects us all. We amend so that we, the people, can create a more perfect union. And when we add new ideas to our fundamental governing charter, our Constitution, we are amending America. Thank you very much, and I am open to answering any questions, either from here in the theater or from online.
Thank you. Thank you very much, Christine. That was fantastic. I personally do not have any questions because it was such a well-done program. It looks like we have some folks who are interested in asking you questions that are on site. So, sir, I'll hand it over to you.
Hi. Actually, I have 2 questions. I think it's correct at the time the first Congress approved the proposed originally 12 amendments. They didn't call it the Bill of Rights. And in fact, the first 2 had nothing to do with rights. So my question there is, when did it become known as the Bill of Rights, and how did that happen? And my second question is, how many amendments have been submitted to the states, essentially approved by Congress but not ratified?
Let me answer your second question first. There have been 33 amendments
Really?
that were proposed by Congress and sent to the states, but they failed to be ratified. One of those amendments speaks to what you were just saying about that Congress passed 12 amendments, actually, when they wrote what became known as the Bill of Rights. And so that was one of those that didn't make it. And you are correct that it didn't become known as the Bill of Rights when it was introduced. People spoke of bills of rights, and of course the English Bill of Rights existed already at that point in time. But it was definitely a 20th century phenomenon that led to people referring to it as the Bill of Rights. And that has something to do with what I mentioned in the presentation about the 14th Amendment and the incorporation of the Bill of Rights to the states. It was when that started happening, which the first instance of incorporation was in the 1920s, and the most recent one was in 2008. But when the Supreme Court started applying the Bill of Rights to states too, that's when most Americans actually started to be directly affected by it in a more concrete way than they ever had before. So that was one reason. Another thing is when we started to move towards the mid-20th century, there was events happening worldwide that caused people to focus more attention on the Bill of Rights, including, importantly, World War II. And in fact, what happened was in 1941, President Roosevelt was already planning on celebrating what would then have been the 150th anniversary of the Bill of Rights, similarly to how we are now celebrating the 225th. But then Roosevelt was planning on noting that event, which was December 15th, 1941. And then, of course, Pearl Harbor happened on December 7th, 1 week before. And that put the celebration of the Bill of Rights in stark relief. And President Roosevelt gave a speech, which you can hear if you go into the gallery, in which he defines why we were fighting in World War II as a defense of the rights listed in the Bill of Rights.
Okay, thank you.
Mm-hmm. Yes?
Rules under the Articles of Confederation for supplanting the Articles of Confederation with the Constitution, and were they followed?
That's an excellent question, too, and that speaks directly to how we got Article 5 of the Constitution, which provided the rules for how we amend. And the Articles of Confederation had required unanimous consent of all states for any amendment to the Articles. So it was when problems appeared with how the Articles are working, that was when the idea for having a constitutional convention was called. Of course, they didn't call it a constitutional convention then. They called a convention for proposing amendments to the Articles of Confederation. But after they arrived, and since Rhode Island didn't bother to participate, they knew that there was no way that they were ever going to get unanimous consent to any proposed changes to the Articles. So they pretty much just threw it out the window and started new, which actually went against the instructions from their own states. But I guess they decided to do it now and ask for forgiveness later, and it seemed to have worked out.
I'll ask another after this one.
Okay, sure.
Well, I have a preface to say, have you changed the exhibit since it opened at all?
Not yet, but the exhibit will be open for a year and a half, and because the National Archives is in the forever business, and we need to make sure that the documents that we have on display here are kept forever for not just us, but for future generations. We do change the documents periodically for conservation reasons. So if you were to come visit the exhibit again in 6 months or so, you will see some different amendments, some different documents.
My question was, in view of the importance of some of the ones that you mentioned on the screen about the ones that are possible, I didn't think they were notated as being currently. So it seemed to me that they were kind of all together in no semblance of importance. And I just wondered if you could if there'd be a way of notating. I don't know whether I can separate my profound desire to see the Equal Rights Amendment pass, but I just thought nothing was, added, which I thought it should be, for how long it had been in the works since suffrage and how many attempts there had been made, as opposed to, less important attempts. Thanks.
Right. So as I mentioned in the presentation, the exhibit has been organized by those three broad themes that we saw when we looked at the list of 11,000 amendments. So those that relate to rights, those that relate to powers, and those that relate to the structure of government. We did not make any attempt to say what is more important than another, and we do invite our audience to make those decisions for themselves. That said, in particular relation to the Equal Rights Amendment, which you did mention, one of the things that we discovered when we were looking at that list of 11,000 proposed amendments is that of that 11,000, the Equal Rights Amendment has been introduced more than 1,100 times. So that's about 10%. And I don't believe there's any other one that even comes close to that number. So clearly there has been a lot of support for that across time. And I do know that last time I looked, which has been a few months ago now, but last time I looked at the amendments that have been introduced in the current Congress, in the 114th Congress, the ERA had been introduced at least 4 times. So even just this year. 4 times. 4 times in this current Congress. So again, it is something that is still seen as an important issue.
For the initial ratification of the Constitution, how many states needed to ratify?
3/4 again, so 9 out of the then 13 is when it would go into effect.
And you identified 6 or 7 which were unconditional in their ratification, but had recommendations for a Bill of Rights.
Yes.
How did the other 2 or 3 required ratifying states become ratifying states?
They just said yes and nothing else. They said, yes, we ratify.
Without conditions.
Exactly.
Thank you.
Can you go to the microphone?
So you're looking at some documents which may be 150, 200 years old. People spoke differently then, they wrote differently then. What are your thoughts on that?
Well, I have worked here at the archives for over a dozen years, and so I'm actually quite used to reading documents that are 200 years old and the way that people wrote then and the different style of handwriting and that kind of thing. So I think it's absolutely fascinating. I think it's definitely a way that you can look into the differences in how people thought at the time. And just the tone that people used in the language choices that they made were really quite indicative of the way that they thought about things. I showed an amendment, the one that was about abolishing the 3/5 clause. If you had the chance to actually read the text of it while I was on the screen, you'll see that the language used was incredibly deferential towards Congress, and they'll say things like, "We humbly pray that you will, make this change that we're requesting of you," and things like that. So it's really interesting to read old documents like that and see how they phrased it. It's good.
Do you know how many amendments have been introduced in the current Congress? And is there anywhere where it's broken down by category, like how many in this area, how many in that area?
Again, last time I looked at the current Congress, I think there was somewhere more than 30 constitutional amendments that had been introduced. But again, I haven't looked in several months, so I don't know. If anybody who would like to look can go to congress.gov and just do a search for constitutional amendments. But narrowed down to the current Congress, the 114th Congress.
And you said 4 dealt with the ERA. Do you have any idea what others are kind of repetitive, so to speak?
Well, as I said in that, as I showed in this slide in here, these were the top 4 introduced amendments in terms of the frequency of being introduced. So all of these 4 listed here have been introduced more than once in the current Congress.
Okay.
So that's the Equal Rights Amendment, as I've already mentioned, the Balanced Budget Amendment, which I think was the most popular of these 4. But I don't, offhand, I don't remember how many times. Campaign finance reform, although those, I kind of lumped those together. There were several, the specific details of each of those was a little bit different. And then, of course, congressional term limits. So offhand, I don't remember what some of the odds and ends ones were.
Hi, another question. So, as I know you know, in addition to the Congress submitting amendments to the states, the Constitution says the states can have conventions, and if 3/4 of them, I think, propose amendments, they get submitted back to the states for ratification. I know there's a current move underway, particularly around the Balanced Budget Amendment, to have state legislatures call for such a convention. I know none has ever happened, but has there ever really been a big move in the past to do that? Or what's your sense about why that's never happened before?
Yes, so just to clarify for those who aren't familiar with it, when you read Article 5 of the Constitution, that's the section that describes how you make an amendment. It actually provides 2 paths for proposing amendments. All 27 of our ratified amendments have happened the same way, which is that Congress, by a 2/3 vote of both houses, has proposed it to the states for ratification. But as you said, Article 5 of the Constitution does offer another way to go about doing that. And what it says is that when 2/3 of the states apply to Congress, Congress shall call a constitutional convention at which the states can send delegates and they will actually write amendments there. And once that convention proposes those amendments, then they still have to go through part 2 of the process, which is that then 3/4 of the states have to ratify the amendments. But as you mentioned, that convention method, as it's usually called, has never been used. And as far as I know, the closest that we have ever come to actually having that constitutional convention was in the early 20th century when there was the movement for the direct election of senators, which I mentioned in the presentation, which became the 17th Amendment, ratified in 1913. And that was rather interesting in that it was the state legislatures themselves that had the power to elect senators. And yet the state legislatures were then applying to Congress, or they wanted a constitutional amendment to actually give up their own power to choose their senators because it was causing so many problems for them, and because of the popular Democratic move to expand, to give that right to select senators to the people. So I know that, or in my research, I came across many of those state applications for a constitutional convention for the purpose of amending the Constitution for direct election of senators. And one of those applications is on display in the gallery, so you can see that. Okay. So I think that's the closest we've ever come. And I think they came maybe 2 states short of that before the Senate decided to get ahead of that game and actually propose the amendment themselves, which they did in 1911.
Thank you.
Thank you, Christine. It looks like we have one more question.
Okay, you were just talking about the election of senators. In your presentation, you talked about the election of the president. You talked about it in terms of picking lots. You're talking about the Jefferson Burr election. In your research, are there any other way we can pick the United States president?
Well, I will say that, anecdotally speaking, since I haven't done a count, I would guess that behind the Equal Rights Amendment, the second most popular topic for amending is how we choose the President of the United States. So if you took all the different proposed ideas, like direct election of the President or electing the President by lot, if you kind of put those into one topic together, it's probably the second most common one. Now, I hope that somebody will take that spreadsheet that I was just talking about that's available on data.gov, and I hope somebody will actually do that official count. Because the ways in which people have proposed to do that have been so various that it wasn't easy to do a count, like it was to just look at equal rights for men and women, equal rights for men and women. That was really easy to pick out of that list of 11,000. Again, I'm guessing here since I haven't done the count, but somebody else can use that list to do it. I think the third most common topic would be actually school prayer. And perhaps the reason why that rose up is because there was so many.
Any other examples of how you pick the United States president?
Oh gosh, offhand I can't remember any of the details. But I know that there was lots of options. Most of them are for direct election, for abolishing the Electoral College altogether. Yes. Mm-hmm. Yes.
Thank you, Christine. This is Andrea. I'm going to close the program up today. Thank you, everyone, for attending. I also would like to take this opportunity to thank our captioner, Kim Piper, and our audiovisual staff. Thank you, Christine Blackerby, and thank you, everyone, for attending today's presentation. Please know that the presentation video recording and the slides will remain available on this YouTube webpage. And on behalf of the National Archives and our presenter, thank you for joining us.
Thank you.